Did you act as a wonderful person? Which is a blessing.
We can get started. We can go on the record. We are here in two cases, although they are joined for purposes of the factual issues. Case 687531, State of Ohio versus Jayden Sorensen. Good morning, Mr. Sorensen.
Good morning, Your Honor.
Mr. Sorensen is in court with his attorneys, Henry Hilo and James Hoflich. Good morning.
Good morning, Your Honor.
We are also here in case 685345, State of Ohio versus Katherine Treadway. Good morning, Ms. Treadway.
Good morning, Your Honor.
Ms. Treadway is in court with her attorneys, Jim McDonald and Mary Jo Tipping.
Good morning.
Good morning.
Good morning.
On behalf of the State of Ohio, our prosecutors Kevin Filiatro and Eric Collins. We are here for sentencing on both of these cases. On behalf of your client, Mr. Hoflich, Mr. Hilo, is there any reason not to move forward?
No, we're prepared to go forward. Yes, Your Honor.
Have you also had the opportunity to review the pre-sentence investigation for your client?
Yes, Your Honor. Yes, Your Honor.
Thank you. I have received the supplemental information that you've submitted on behalf of Mr. Sorensen, and I have reviewed all of that, all of those certificates, letters, everything you've included. On behalf of your client, Ms. Tipping or Mr. McDonald, is there any reason not to move forward?
No, Your Honor.
And have you had the opportunity to review the pre-sentence investigation as well as the sentencing memoranda prepared on behalf of the State of Ohio?
Yes, Your Honor.
Okay, thank you. Mr. Filiatro.
Thank you, Judge. Your Honor, would you like the state's comments as to both defendants or one at a time?
How would you prefer to handle this? The court is fine to defer with whatever works best for you.
I can speak about both of them, Judge.
That sounds fair.
Your Honor, as you know, we're here because on September 28, 2023, a life was taken, a young, innocent life, 3 years old, doing probably the most innocent thing that can be done which is just sitting in his car seat while his mom is about to drive him somewhere. An act that happens every day in every part of this city and every city in this country. There are certain places where kids should be safe. Their home, their school, their car, with their parents. And Luis wasn't. And his lack of being safe that day had nothing to do with his mother, had nothing to do with anyone he was with, except for the upstairs neighbor, Katherine Treadway, and what was going on in her life. That's why Luis Diaz wasn't safe. That's why he ended up dead that day. Your Honor, you sat through the trial for Juan Davis and Devonte Parker, and so you know the facts of what happened. And we got into a little bit of what Katherine Treadway was doing that day in that trial, but not all of it. I'll get back to that in a moment. I want to point out at this point, with me today, Judge, are members of Luis Diaz's family, as you can see. They're here, they've been here every step of the way in this case. Unfortunately, his mother, Angelica, is not with us today. She is ill and is unable to be in court today. As you can imagine, Judge, this is very difficult for this family. Coming into court, I'm not sure any were able to say anything in court today. And a lot of which is because it's just so hard to do. So I'll do the speaking. Let's begin with Jayden Sorensen, Judge. 16 years old at the time, and you know from this trial that before September 28, 2023, Mr. Sorensen was no stranger to guns, no stranger to using them for show, for play, for all sorts of purposes. It was all over his phone, some of which were poses involving other people, most notably Devonte Parker. That didn't matter at all until before September 28, 2023, but it certainly mattered after. Jayden Sorensen made choices that day. He made choices to go with the adults. He made choices to take a gun with him, to follow Devonte Parker to that spot behind the trees, and to pull the trigger of the gun he was holding. Those choices were all bad, and he is here to pay for them today. But I want to say this about Jayden Sorensen as well. When he was arrested 2 days later, he made another choice. And he chose to tell police what happened. And I note this because in a case full of horrible decisions made by all of the adults, when it came to the death of a child, it took the courage of another child to tell the police what happened and who did it. That's noteworthy. It's noteworthy about him, and it's noteworthy about the others who, when given their opportunities, did not make that choice. So when it comes to Jayden Sorensen, Judge, you know what he did, and we're asking for you to sentence him within the range that's been agreed to and agreed to be recommended today. We're going to recommend that range to you. somewhere between 10 and 20 years for him. But I want to note all the things about Jayden Sorensen, the things he did on the 28th and the thing he did on the 30th. When it came to resolving his case, I did not feel the need to even get another statement from him. I did not feel the need to sit down with him prior to entering the plea. Because he said what happened. And of course, he lied during that interview, as many people do when they speak to the police. But he told the truth about who did it, who was with him, and some of the things he didn't know were why it happened, why this car, why this street, why this house. He had no idea. And that speaks to his and Devonte Parker's involvement, Juan Davis's involvement, and Katherine Treadway. So let's talk about Katherine Treadway now, Judge. As you know, in August of 2023, Katherine Treadway, who lived above Angelica and her family, had an incident with Juan Davis. That incident led her to call the police and for the police to come out and to take statements. They took a statement from her and they took a statement from Angelica, because that was a case of an alleged aggravated burglary and domestic violence. So of course they'll talk to Katherine Treadway, the victim of the incident, and anyone else who lived in that same building. That would be Angelica. He was not arrested until after his indictment in that case on September 15th. September 13th he was indicted, September 15th he was arrested. September 19th he was arraigned and made bond. And part of that bond was no contact with Katherine Treadway, court supervised release, and GPS monitoring. And then we move on. His first pretrial is September 27th. Why do I mention all this? Because Katherine Treadway, after he was released from jail, had many communications with Juan Davis. She texted him many times. She called him many times. And it was after that pretrial on the 27th. First off, that morning she told him, "I'm not coming to court. You told me not to, and I won't." She wants him back in her life. And it's sometime after that, later that day, is when she begins calling him using star 67. I looked at those records over the weekend. Between that time, which was around 12:30 on the 27th through 2:30 on the 28th, so that covers the time during which the shooting happened, she called Juan Davis 99 times using star 67. Not once did she call him without using star 67. Which begs the question, what was that for? Was that for Juan Davis to not know she was calling? Or was that for everyone else to not know she was calling? 99 times, and she spoke with him several of the times. I note some of those in the sentencing memo here. And when you look at this in conjunction with what was going on with Juan Davis, she wanted him back in her life. He wants this court case over. She's telling him she's not going to court. It puts what happened in unique light. Because, and as you know, Angelica testified that she was leaving this house. She packed up her things, she put her kids, she didn't put her kids. Katherine Treadway put her child, Luis Diaz, into his car seat. Angelica didn't notice it at the time, didn't know its significance, but Katherine Treadway also moved her car out of the driveway and down the street. All the while having all these phone calls with Juan Davis, someone who wasn't supposed to be there. And because of his GPS monitoring, he didn't go there. He went right around the corner and dropped 2 guys off to do what he wanted. But how would he know who is there other than to get that information from Katherine Treadway? Treadway calls him so many times. 1:04 p.m., 48 seconds, just to highlight a few. 2:03 p.m., 1 minute, 38 seconds. 2:10, 6 seconds. 2:10, 17 seconds. 2:12, 5 seconds. 2:12, 28 seconds. 2:14, 47 seconds. Why does this all matter? Because it's during all that time when Juan Davis has the idea to go and switch his car, to get the Mercedes, to get Sorensen and Parker, and to drive over and have them do something. Something specific. Take these guns, go to that spot, shoot across the street, shoot into a car. The timing is too precise to be random. That the car they shot into was driven by Angelica and leaving at that moment. Katherine moved her car. She knew what was going to happen. All of this the court knows from the trial. But what I mentioned earlier, the contrast between Jayden Sorensen, who when he was arrested, told the truth. Here's what Katherine Treadway did that day. She called 911 after calling Juan Davis. There was a witness who heard her complaining about his involvement in this shooting that just happened. But she calls 911, doesn't mention his name. Police go out there, and there's body camera of many police officers speaking to her. She literally has Luis Diaz's blood on her pants and does not mention Juan Davis's name. Does not mention what she knows. Surmises that maybe this involved Luis's father somehow. She does TV interviews. She was on Channel 3 that night. She was on Channel 19 that night. She had text messages from Channel 5, all of whom wanted to talk to this person who appeared to be a good Samaritan and a witness to this horrible tragedy. Never once mentioning she knew who was involved. And then that night, where does she go? She takes her phone, gives it to a relative. She takes another phone and goes and sees Juan Davis at his house in Cleveland Heights. Never once mentioning to anyone what she knows. She's arrested that night. And that's the difference. That's the difference between her and a child that was involved in this case. In one of these police interviews, she's holding Ezekiel, who Angelica left with her and the neighbor to be with her son who died. She's literally holding the 11-month-old, knowing what happened and not saying. As I said, Judge, the adults in this case made choices. And those choices have consequences. Katherine Treadway, Your Honor, knew what was going to happen that day. She knew what did happen that day. And then pretended for the world that she didn't. All for the benefit of Juan Davis, who we'll get to later this morning. If I could just have a moment, Judge.
You may take your time.
like to bring up a member of Luis's family.
Good morning. Can you tell me your name?
Leonor Rivera,
Could you spell that, please?
Leonor. Rivera's Rivera.
Good morning, Ms. Rivera. What are you holding?
My hero. This is Luis Diaz. This is my grandson. And I want justice for my baby. They took him away on September 28th. He was our hero. This is my family. And my life is not the same no more without him. He was special. I have other grandkids, but he was very special. They took my heart, and I want justice for this. His father is here, and he can't. Our life is changed without him. So,
Thank you so much. I'm so sorry.
thank you.
Good morning, Your Honor.
Good morning, sir. Could you tell me your name?
Yes, my name is Christian Tolet.
Could you spell that, sir?
Christian, and the last name is Taulet.
Mr. Tollett, what would you like me to, what are you holding?
This is a picture of my grandson, Luis.
And it's you holding him?
Yes.
How old was he in that photo?
To
Okay. What would you like me to know, sir?
First, I'd like to thank God for the opportunity of another day. The Cleveland police for doing their job and the quick response, capturing the people involved of taking my grandson's life. Also the prosecutors for taking it all the way and making sure that they are paying for what they did. I don't think I was gonna say this, but for the young man that stepped up and made it clear, let everybody know what happened, how it went down. God will probably forgive you. I've been here 25 years, never had a problem with the law. This is the first time I come here, and the reason it's not the best. I miss my grandson a lot. And I used to see this on the news. Never thought it was going to happen to me or my family. And it did. And now, when I see this type of cases on the news, I cry. I know how that family feel, how bad they feel, how all the members feel. And what I want to say is, I hope that you give them the maximum sentence that is required by law for the crime that they committed. That's what I can say. Thank you, and have a great day.
Thank you, sir. I'm so sorry. Good morning.
Your Honor.
Can you tell me your name?
Salinas Rios,
Could you spell that for me?
Celines. Rios, Rios, Callahan's. Callallahan.
And you, sir?
I'm Luis, the father.
Can you, is your last name Diaz?
Yeah.
D-I-A-Z, correct? Okay. Who would like to speak?
I want to say something. I would like to address you, but I'd also like to permission to address Katherine when I'm done addressing you guys.
You can, but when you have your comments to Ms. Treadway, I want you to look at me while
I
you're
will.
doing that.
I can
Thank
do
you.
that.
Please, go ahead.
Angelica is a gift to me. She's a gift to me from God because she's my goddaughter. To know what it is to be her child, I don't know that, but to care for one, I do. Luis Angel was more than just my goddaughter's son. He was my breakfast buddy. We would eat breakfast via video, sing, have morning. He would tell me about he was gonna go to his grandma's, or if he went to his abuelos, or, you know. At the funeral home, they asked what was his likes. It wasn't too many, he was only 3. My goddaughter and Louis, they were young, but they were trying to build something. And the family, his family, pulled together, whatever, you know, you do what you gotta do. They went, he got a job, they had the 2 babies, they tried to make a life. Sometimes things went left, sometimes things went right, but they always met up in the middle with the kids, you know. I have to thank the court for everyone that's here, because this ain't just, I know you guys see this every day probably, unfortunately, but to us this is like, there's no words. They got another son, but it's another son. It's not that son, it's not his first son. And the other son feels grown with joy and light. But there's always going to be that part that's always going to belong to somebody that's not there. And I don't know who's parents and who's not parents, and if your mothers, godmothers, cousins, sisters, if you've taken care of a child, that's a joy, that's an honor. For Katherine, I want her to know we treated her like family. When we ate, she ate. When I came over to the house and I bring something for the boys, I make sure I bring something sometimes for her kids too. I have sadness for her. Sadness. I have sadness because she's looking for something in somebody that's not going to give it to her. Never. You got kids. You got gifts that were given to you. Look for that love in them. Look for that love in your kids. And I pray that God watches and puts a hedge of angels around them, because they deserve that. And the odd thing is that I pray that for you too, because you was family to us.
Mr. Diaz, so just for the record, she referenced her goddaughter, Angelica, Angelica, and the name of the little boy is Luis Angel, Luis.
She has a J in her name, I'm sorry.
Can you spell-
Angelica, her name is Angelica. A-N-J.
Thank you. My apologies, I meant
No,
no
I'm just
disrespect.
saying. No, I know.
Yeah, I want to make sure
I'm
that.
the crazy aunt, I'm sorry.
I love it. I love that. I want to make sure we have a record and an accurate record of what you have said. It's very important. Mr. Diaz, anything you wish to say? You were here every day.
It's hard to talk. I want to. All I can say is it's been very hard for me and this whole process and everything. I said, I'm sorry.
You take your time, sir, and if you don't want to say anything else, you don't have to.
I want to say thank you to the prosecutors, the detective, and the police, and you as well. All I can say is all of this has been hard and stressful. I haven't been myself since I lost my first child. That's all I gotta say. Thank you.
Yeah, the photos that you're holding are beautiful. That little baby, you can see the joy, just even from, you're probably 15 feet away from me. It just radiates joy, that little soul. Thank you for showing them to me.
Thank you.
Judge, with that said, we ask you to sentence these defendants. We ask you to use your discretion in both. When it comes to Katherine Treadway, Judge, we're asking for you to sentence her within that agreed range, 15 to 22. And recognize the role she played here. Thank you.
Thank you. On behalf of Mr. Sorensen.
Thank you, Your Honor. I would like to say a few things on his behalf. He has a family member and another individual that would like to speak, and he would also like to address the court. But I'll go first. What the prosecutor stated was correct. Summer of 2023, my client was making horrible decisions, which culminated in this horrible event in September of that year. And he came to a realization that he had to make a change. And as the prosecutor also stated, it was at that point that he started making some good decisions, starting with the fact that his co-defendants in this case, who are all in their 30s, are not his friend. They're not looking out for the best interest of a 16-year-old. And he started to try to earn some forgiveness. He knows he may never earn the forgiveness of Luis Diaz's family. It's not up to him. But he has made several decisions since then that doesn't mean that he shouldn't try, Your Honor. And he has been trying. When he addresses the court, I do believe that you'll find his remorse to be genuine in this case. He's a father now himself. This is a horrible incident that he was involved in. Unfortunately, he can't go back in time and change that conduct. He's also taken responsibility. The prosecutor was also correct when he initially spoke with the detective. At a minimum, he was minimizing his role. But you saw 2 separate days on the witness stand him take responsibility for his conduct. And I think the prosecutors would agree he was instrumental in bringing 2 killers to justice. And that's what he did. Now, in addition to taking responsibility for his role, for his conduct here, he's also demonstrated to the court that he can change his behavior. You do have several letters, some written. I know Mr. Dolezal's here. He wrote a letter. He is the reentry director. He spent a lot of time with Jayden when he was in the detention center in juvenile court. I did also have a chance to speak with his social services coordinator in the detention center. The entire time he was in the detention center, they have a behavioral scale. He was always at a high level of behavior in the detention center. Something that he's very proud of. He achieved his high school diploma in the detention center, and he knows at best case scenario for him, he's going to spend 10 years in prison. But what he wants to do is continue his education in prison, take advantage of whatever programming they have, as he was doing in the detention center this entire time. And hopefully, Your Honor, he's demonstrated to you that even though, and here, this is not to in any way minimize his conduct or his role in this, but to show that he has taken responsibility, that he has, 10 years for a 16-year-old is a long, long time. He's 18 now, but he was 16 at the time. And he is, hopefully, he's demonstrated to this court, to the Diaz family, that the low end of that range, even potentially a 10-year sentence, is warranted for his conduct because he stepped up to the plate. Because the youngest person involved in this is the one that took responsibility and made sure those that were also responsible were taken to justice, Your Honor. And I know Mr. Dolezal had a couple of comments he wanted to supplement that letter that you have. We would also ask you to consider the other letters and certificates showing that he has tried to make the most of his time and better himself, and to ensure that when he does get out, he's not making the same bad decisions he did when he was a 16-year-old. If I could introduce Mr. Dolezal.
Yes. This is Spencer, S-P-E-N-C-E-R, last
Yes, Your
name D-O-L-E-Z-A-L, sorry. He is the Reentry and Advocacy Director and Mentor, Writers in Resistance.
Residents, Your Honor.
I'm having trouble
You're
today.
fine.
Okay, Mr. Dolezal, what would you like to say?
So I just wanted to add to the letter. So in over a decade of doing this work with the population that Jayden's a part of, it's rare to find a young person who was making the poor decisions that they were making, who switches and decides that they are ready to move forward, that they're ready to show their remorse with their actions. So in our time working with Jayden in our creative writing workshops at the Juvenile Detention Center starting in November of 2023, so shortly after he arrived there, to his time being involved one-on-one with me in our mentoring program, Jayden showed that he was committed to moving forward, to changing not only his mistakes and trying to atone for those and show remorse for what he had done and what he was involved in, but also to change the environment that he was a part of. So he had a reputation at the Juvenile Detention Center as somebody who brought others up with him as he was trying to do the right thing. He voluntarily involved himself in as many programs as he could while he was there. And in my professional experience, it's, like I said, it's rare to have somebody that committed to moving forward. And I think he shows very high potential for rehabilitation. So from my professional stance involvement in his case, I would just ask that you are lenient in that sentence. Look at the 10-year side of that range, knowing that he's willing to serve that time out of his remorse for his actions, but also giving him the opportunity to rehabilitate and re-enter society as a productive member who's willing to move forward and help others move forward. Thank you, Your Honor.
Thank you.
And his name would also like to speak.
Okay. Good morning, could you tell me your name?
Shannon Carpenter.
Can you spell that?
Shannon, S-H-A-N-A-N. Carpenter, C-A-R.
Okay, I can barely hear you, so take a moment to get yourself together so that when you speak, I can hear you. And that your words will have more meaning.
I'm sorry. Carpenter, C-A-R-P-E-N-T-E-R. I'm a here to I thought I could do this. Okay. Approximately a year and 5 months ago, my nephew made a bad decision. I think that on behalf of him and the rest of my family, first we'd like to apologize for the loss of Luis. Since then, he has realized that he has a daughter also, so his daughter's gonna grow up without him, you know, as long as that he's incarcerated. And we're hoping for the best possible outcome. That for his siblings and his mother, and for their family as well, just to get the justice, because we all understand that this is a process. And we just ask you to be merciful.
Okay, thank you.
Are you arguing for Jayden
Mr. Sorensen, is there anything that you wish to say?
Yes, Your Honor.
Go ahead, sir.
Before I get too deep into my statement, I want to first apologize not only to the victim, but their family, my family, and also the courts for being here under the circumstances. I've sat in my cell for months trying to figure out what I would say when the time came. And now that I'm here, I still don't feel like my words show how sorry or remorseful I am. It still doesn't excuse the fact that of me knowing right from wrong. So I pray asking God for my victims for forgiveness. I prayed asking God for knowledge, wisdom, and a deeper understanding of life. I feel like he answered my prayer shortly after, incarcerated, I found out that I had a baby girl. Now I see everything more clearly in a different light. The thought of somebody hurting my baby girl will crush my world, so I feel for the family. Throughout life, I had a little to no guidance on how to navigate life. Because of that, I made mistakes. In my head, I turned everyone from a mistake into a lesson. I've learned that one illegal thing could take you away from your loved ones. I've learned that it could scar someone who is on the same journey as me. I've learned to ask for help instead of trying to take the world on my shoulders. I learned I should be a pillar to the community instead of a problem. Basically, I learned who I am. I can go on and on about but we would never get on with these proceedings. Before I end this, I would want to apologize to the victims again. Hopefully one day they can forgive me. Thank you for your time, your honorable judge, and whatever time you give me, I thank you in advance.
Thank you, Mr. Sorensen. You can have a seat.
And thank you.
Thank you.
Lastly, I would just say that you have a wide discretion here of 10 to 20 years. We would submit to you that while our client's conduct was horrible at the time, that he has done nearly everything he can since that day to earn this family's forgiveness and to hopefully you find more than a 10-year sentence. Thank you.
Thank you. Speak on behalf of Ms. Treadway. Ms. Tipping, when you're ready.
Thank you, Your Honor. Your Honor, on behalf of Katherine Treadway, we've had the opportunity to review the pre-sentence investigation report that was ordered by the court. In addition to the pre-sentence investigation report, we have submitted to the court as well as to the state of Ohio a psychological assessment of Katherine Treadway that was authored by Dr. Katie Connell, a forensic psychologist, who over the course of this case has met with Katherine Treadway a number of times. And our purpose in submitting that to the court prior to sentencing was to provide the court with a lot of additional information regarding our client, Katherine Treadway. But as the court can probably see from reviewing that evaluation, there's a large portion of it that talks about the, I guess I could only describe it as extremely dysfunctional relationship that Katherine Treadway has had over the course of years with Juan Davis. Our client is 31 years old now. She was 15 to 16 years old when she first got involved with Mr. Davis. And I'm not standing here to try to make this about blaming Juan Davis, because people make their own decisions. But I can only describe that relationship as highly dysfunctional, abusive, controlling, intimidating, all of those things. And it was a relationship that Ms. Treadway had a very difficult to impossible time of getting herself out of. And if there is one good thing that comes out of the resolution of this case, she knows that she's going to prison, is that hopefully this will bring a conclusion to that relationship. Probably the only good thing that came out of that relationship was 2 of her children that she had with Juan Davis, who are now being cared for by other members of Ms. Treadway's family. So in addition to that psychological evaluation that we submitted to the court, there were a number of letters that we submitted to the court as well as to the state of Ohio from Ms. Treadway's family members. In that regard, there are a number of family members that are here present in support of Ms. Treadway that are here today. She has 2 sisters that are present, 2 nieces, 1 sister-in-law, and 1 of her brothers. So first and foremost, Katherine Treadway is before the court today accepting responsibility for her involvement in this. She was not a person that sat through the trial of this. She is not a person that chose to go to trial in this. Back on January 27th, we had argued a motion to separate her for purposes of trial, and ultimately that was a request that was granted by the court for a separate trial on her behalf. The very next day, on January 28th of 2025, she entered her plea of guilty to involuntary manslaughter with a 3-year gun specification, 2 counts of attempted murder, a count of felonious assault, and a count of having weapons under disability. By way of her plea, by way of being here before the court today, she accepts responsibility for her actions, for her role in this. And I can stand here and talk to you about how she's apologetic to the family of Luis Diaz, which we are, a huge loss, an irreplaceable loss. But that means much more coming from Ms. Treadway than it does coming from Mr. McDonald or myself. In reviewing what has been submitted to the court by way of the PSI, by way of the psychological evaluation, I think the court can come to the appreciation that while Katherine Treadway has made some huge mistakes, bad decisions, no doubt about that, she is a person that has no criminal history. She has no history of violence. She has no history of antisocial behavior. She has no history of addiction. She's does have a history, again, of being involved in a highly dysfunctional relationship with Juan Davis. And I can't begin to explain to the court, how that relationship plays into a lot of the bad decisions that she has made along the way, including the behavior that brings us here today. And she's not making excuses for that. We're not making excuses for that. She was clearly at the property that day. There's never been any allegation that she was firing a gun, that she had possession of any weapon. I know that it is the state's position that her role in this case was different. She blames herself for putting herself in this situation. She knows that she is going to serve a lengthy prison sentence. She has lost a lot in her life, not nearly what the family of Luis Diaz and other families have lost here. I don't mean to put that out there as any sort of a comparison. But she has made her mistakes, and she will live with her mistakes. We are asking the court, she stands before the court, first and foremost, Judge, prepared to accept whatever sentence the court imposes on her. But we are asking the court to consider imposing a 15-year prison sentence on Katherine Treadway. She's accepted responsibility for her role. Even the probation department noted her as being a low to moderate risk in their risk assessment. And I think that's probably given the fact of her lack of a criminal history. But again, she is prepared to make the best use of her time, to accept whatever sentence the court imposes on her. And given that, I think she is hopeful that once she moves forward, makes the best use of her time in the institution, that in some way she will come out of this a better person than she went in. Thank you, Your Honor.
Thank you. Ms. Treadway, is there anything that you wish to say?
Yes, Your Honor, and I also would like to say something to the family as well.
Okay, go ahead.
I would like to apologize to you and say I apologize for the role that I played. And Your Honor, I would like to say to the court, I take full responsibility for the role that I played, and whatever time you give me, I'm gonna go down there and make the best of my time. That's it.
Okay, thank you. Okay, I have considered everything that's been presented today. I've reviewed the documents that were filed in support of both Mr. Sorensen and Ms. Treadway. I've reviewed the pre-sentence investigation. And even though these two individuals resolved their cases prior to trial, I sat through a 10-day trial. So I'm well aware of the facts for each of these individuals. I agree wholeheartedly with the state of Ohio. Like, the irony that that little baby was sitting in his car seat, the safest place where he should be, in his car with his mother, and that's where he lost his life. The irony of that will just never be lost on me, and I keep thinking of him. I don't know that I'll ever forget this. Ms. Rios, you said that we see this all the time. We don't. We don't see this all the time. This case is different.
She put him in the car. She put him in the car.
I know.
She had time to say something.
I know. I want you to know, though, that your case is different. And it is not an everyday thing. Your experiences, your hurt, it's different than what I see every single day. I see most of this family who has been here every single day of this trial. Your faces are familiar to me. I don't know that I'll ever forget, he was 42 inches tall. He was tall. He was tall. That's tall for a little baby. And the 4 individuals involved here stole that baby's future. He's never going to get the chance to see how tall he eventually would have been. He's never going to get the chance to grow up, to fall in love, to get a driver's license, and then maybe one day put his own kids in the safest place that they should be, which is the car seat. And for that, I am so incredibly heartbroken for all of you. I cannot even begin to give you closure because he's gone. I can give you accountability. And I thank you for the courage it took for all of you to be here every single day of this trial and for each of you to come here today. Mr. Sorensen, I'll start with you. I have considered the purposes and principles of sentencing under Revised Code Section 2929.11, the serious and recidivism factors relevant to these offenses and yourself pursuant to Revised Code 2929.12, and the need for deterrence, incapacitation, rehabilitation, and restitution. I do not condone what you did. Who knows the position you would have been in had your weapon fired. But you will pay the price for your decisions that you made that day. You've accepted that. You accepted that plea and you accepted the sentence that comes with it. But I do see something different in you. The state of Ohio has expressed similar sentiments. I even felt it when you were testifying during the trial. I felt your remorse. The decisions that you made after your arrest allowed justice for that baby, for Ms. Figueroa, for Mr. Mateo, and for Ezekiel. I don't often, and I don't know if I've ever seen people express remorse and regret and then back that up with changed behavior. You've shown that today. You are young. The greatest chance for change is now. So I hope you see it through. Otherwise, you will not only have wasted that baby's life, but your life as well. So, with all of that, count 4 is the qualifying offense, and I'm sentencing you. Well, first of all, the 3-year firearm specification. You will serve that prior to and consecutive to the qualifying offense in count 4, which will be 8 to 12 years. Count 7, the sentence is 8 years. Count 10, the sentence is 8 years. Count 13, the sentence is 6 years. And on count 14, the sentence is 18 months. The firearm specification runs consecutive, and the remaining charges will run concurrent for a total prison sentence of 11 to 15 years in prison. You have 507 days of jail credit that will go towards your sentence. It does not go to the firearm specification time. Once you serve that mandatory first 3 years, then you'll get the credit for the time that you've served. You'll also get credit for the future days you spend here before you're transported to the appropriate institution. After you serve that mandatory portion of your sentence, you do have the right to earn good time credit. It ranges anywhere from 5 to 15% against your minimum sentence for good behavior. I have the right to deny your good time credit, but before that could happen, I would assign an attorney to represent you and conduct a hearing in court. You will be released when you finish your minimum term unless the Ohio Department of Rehabilitation and Corrections determines that you must remain in prison for bad conduct. This decision is made by the Ohio Department of Rehabilitation and Corrections. If you are not released when your minimum term ends, you will serve an additional specified period of time and be given a new release date. You will be released on that date unless you are again denied release for bad conduct. This process repeats until you are either released or until you finish your maximum term. It's going to be difficult. You have to, every single day, remember why you decided to change your behavior. Otherwise, you'll go right back down to the road that you were living before you were arrested. And it's with hope and prayer that that's not what happens for you. When you are finished serving your prison sentence, the State of Ohio Adult Parole Authority will have a mandatory period of supervision. It's called post-release control. It's for a minimum of 2 years, up to a maximum of 5 years. If you fail to comply with the terms of any post-release control supervision, the Adult Parole Authority could modify or extend your supervision and make it more restrictive. It could incarcerate you for up to half of the sentence I just imposed here today. It could charge you with a new offense called escape, another felony where you would face additional prison time. And if you commit a new crime while on post-release control, you could face the maximum penalties under the law for that new crime committed. I'm finding that you are indigent. I'll waive the fines and court costs that are associated with this case. Ms. Treadway. Your case is different. It's a lot different. I will never understand the coldness, the ice in your veins that was needed to put that baby in the car seat, to move your own car out of harm's way, to continue to call Juan Davis, to call Juan Davis first after the gunshots stopped firing, and only then call 911. I will never understand that as a human being. I acknowledge that you have no prior criminal history, but without your actions, Luis would be alive. That I can never disregard. Count 4 is the qualifying offense. I'm sentencing you to 3 years in prison on the firearm specification time, which will be served prior to and consecutive to the qualifying offense of, on count 4, which is 10 to 15 years in prison. Counts 7, 10, and 13, the sentence is 7 years in prison. Count 19, the sentence is 3 years in prison. Further, I am finding that consecutive sentences are warranted in the present case, and I'm ordering Ms. Treadway to serve the sentences on counts 4 and 7. Those relate to Ms. Figueroa and Mr. Diaz, young Mr. Diaz. After reviewing the record and the evidence, I find that consecutive sentences are necessary to punish Ms. Treadway, to protect the public from future crime, and are not disproportionate to the conduct or danger posed by Ms. Treadway, and that Ms. Treadway's conduct involving in this case was part of a course of conduct, and that the harm caused was so great that a single prison term would not adequately reflect the seriousness of her conduct. So the 3-year firearm specification will run consecutive to count 4, which will run consecutive to count 7. Counts 10, 13, and 19 will run concurrent with each other and with the remaining charges for a total prison sentence of 20 to 25 years. It is possible for you to earn good time credit once you finish that mandatory 3-year firearm specification. It ranges from 5 to 15%, and it goes against your minimum sentence for good behavior. I have the right to deny your good time credit, but before that could happen, I would have a hearing and appoint an attorney to represent you. You will be released when you finish your minimum term, unless the Ohio Department of Rehabilitations and Corrections determines that you must remain in prison for bad conduct. This decision is made by the Ohio Department of Rehabilitations and Corrections. If you are not released when your minimum term ends, you will serve an additional specified period of time and be given a new release date. You will be released on that date unless you are again denied release for bad conduct. This process will repeat until you are either released or until you finish your maximum term. You have 508 days of jail credit that will go towards the sentence I've just imposed. It will come into play once you finish the mandatory 3-year firearm specification. When you are finished serving your prison term, the State of Ohio Adult Parole Authority will have a mandatory period of supervision. It's a minimum of 2 years, up to a maximum of 5 years. If you fail to comply with the terms of any post-release control supervision, the Adult Parole Authority could modify or extend your supervision and make it more restrictive. It could incarcerate you for up to half of the sentence I've imposed today. It could charge you with a new offense called escape, another felony where you would face additional prison time. And if you commit a new crime while on post-release control, you could face the maximum penalties under the law for that new crime committed. I'm also finding that you are indigent, that you will be serving a lengthy prison sentence, and I will waive fines, court costs that are associated with this case. Anything further on behalf of your client, Mr. Hoplich?
No, Your Honor, thank you.
Mr. Hilo?
No, Your Honor.
Anything further on behalf of your client, Mr. Tivay?
No, Your Honor, thank you.
Thank you. And Mr. McDonald?
No, Your Honor.
Thank you, sir. Anything further on behalf of the State of Ohio?
No, Judge, thank you.
Thank you. We are adjourned.
Love you, Cat. Keep your head up.
Stay strong, girl. We love you.
Love you, sis.
Your Honor, thank you.
Love you. Take your phone up. Love you with all my heart.
Oh, is it up here? No, it's how long is the judge? Is the judge have something that you write down? No. Oh. No, I just
Hey. Good, how are you?
You were staying.
trying. You know who I saw yesterday? I saw Pat.
Oh, he told me he was over our house.
I saw it at the K&K.
He told me.
And he was like, you know how he is. He was like, this one's so nervous in here. He's like, why? It's not even that busy. He goes, there's just too many options. There's too much going on. I was like, oh my God. I almost did text my kind of being like, Mousy Mouse is at it again.
I don't think she even knew that he was over there. He came over to something. And Sutton came over at the same time.
What more is it?
I can't tell you what it is.
sorry.
It's okay, it was the media earlier.
Yeah, don't point at me.
I'm pointing in a general direction to my left.
Yes, I am. I like give giraffe starty eyes.
Okay, we'll continue on. We are here in case 685-345, State of Ohio versus Juan Davis and Devonte Parker. Mr. Davis is in court with his attorney, Chris McNeil. Mr. Parker is here with his attorney, Kevin Spelletti. Mr. Parker, your second attorney, Joe Lenardo, is unable to be present at this sentencing hearing. Are you comfortable moving forward with only Mr. Spelletti?
Yes, I'm comfortable.
Okay, thank you. On behalf of the state of Ohio, our prosecutors Kevin Filiatro and Eric Collins. We are here for sentencing today. Mr. McNeil, is there any reason not to move forward?
No, Your Honor.
Any reason not to move forward, Mr. Spelletti?
No, Your Honor.
Okay, thank you. On behalf of the state of Ohio, Mr. Filiatro.
Thank you, Judge. Your Honor, when it comes to the sentencing for these two defendants, there's a few housekeeping matters I think I need to go over with the court on the record. I know I addressed them in the sentencing memo, but I need to address them here on the record as well. The first of these is a discussion of merger. Both defendants were convicted of every count, save the two aggravated murder counts, and several of these counts will merge as a matter of law. In fact, I mentioned this in the memo, but I'll mention it on the record here. With regard to counts pertaining to Luis Diaz as the victim, this is counts 3, 4, 5, 6, 14, 15, and 16. For both defendants, the state concedes these will emerge and elects for both defendants to be sentenced on count 3, murder, under revised code section 2903.02a. With regard to counts pertaining to Jose Mateo, these are counts 7, 8, and 9. The state concedes that these counts merge and would elect for the defendants to be sentenced on count 7, attempted murder of Jose Mateo. Counts 10 and 11 refer to Angelica Figueroa. These counts merge. The state elects for them to be sentenced on count 10, attempted murder of Angelica Figueroa. And finally, counts 12 and 13 will merge. The state elects for them to be sentenced on count 12, attempted murder of Ezekiel Diaz. The counts of having a weapon or disability do not merge as a matter of law or fact. I don't think there'll be any objection from the defense on that, but that would be the state's statement with regard to merger. The next thing I'd like to mention are firearm specifications. Juan Davis has been convicted of 1 year, 18-month, 3-year, and 54-month firearm specifications on each count, except for the weapons and disability counts. The state elects to proceed on the 54-month firearm specifications with regard to him. Mr. Parker has been convicted of 1 and 3-year firearm specifications on each of his counts, except for the weapons under disability count. The state elects to proceed on the 3-year firearm specifications. When it comes to the number of firearm specifications, the court must, because we've got convictions for murder and attempted murder here, the state must have at least 2 of these types of specifications. That would be 2 54-month specifications for Mr. Davis, 2 3-year firearm specifications for Mr. Parker, and this is under revised code section 2929.14B1G. That same section allows for trial courts to give more than 2, but there, and I mentioned this in the memo, there is a case that came out from the Ohio Supreme Court, State versus Beatty, 2024-Ohio-5684. It was a plurality opinion, thus is not binding on this court, but in this plurality opinion, the 3 members of the court that agreed with its reasoning found that The statute does not allow for any more than 2 firearm specifications to be run consecutive with the 2 that must be given. In these circumstances, that was an opinion not joined by the others, yet the result stood. So I've addressed this in the memo. I believe if the court is inclined to give more than 2 firearm specifications for either of the defendants, it is defensible on appeal. But of course, this is all up to the court's discretion in how it wants to handle the issue of firearm specifications. But the court must give 2 each at least. Finally, repeat violent offender specifications. And I'll address this now when we begin talking about the facts of what happened. Your Honor, as I said before, I'll say it again because this is a separate and distinct sentencing hearing. On September 28, 2023, Luis Diaz, 3 years old, was in what is supposed to be a safe place. In his car seat, with his mother behind the wheel, his little brother next to him, in his car seat, going for a drive. What we learned in this trial, Judge, is that Luis Diaz wasn't even really supposed to be with his mother that day. He was homesick from school, and but for that, he would not have been in harm's way. And what do I mean by harm's way? People who aren't in his family. People who he didn't even know.
Want to take a minute?
Sure. Yeah, if I could just have a
I
moment.
know.
Judge. Thank you.
Go ahead. Off the record. Hold on, let's make sure everybody's seated.
Yeah.
All right, we can go back on the record. Please continue, Mr. Caliandro.
Thank you.
You're welcome.
Luis Diaz and his family had no idea when they got in that car that people they had never met before had decided to fire 13 shots at them. They had no idea that that car and his car seat were the most dangerous place to be at that moment. And why was that? That was because Juan Davis had decided that bullets needed to go into Luis Diaz's car. Why did he do this? I think we've proven this at trial, Judge. He had a pending aggravated burglary domestic violence case where Katherine Treadway, the upstairs neighbor to Luis and his family, was the complaining witness. But we also know that Luis's mother was a witness in that case too. She gave a statement to police. And Mr. Davis had just gotten out of jail and had a GPS monitor on his ankle, court supervised release. I'll get back to those ideas in a moment. But he gets out of jail and he's got these things and he knows he can't go and do this himself. He knows he wants his court case over. He told as much to Katherine Treadway in text messages. And Katherine Treadway told him she wasn't going to court. And what else do we know? Mr. Davis told the police in his interview he had no beef with Jose Mateo. So what's left to know when we want to know why Luis Diaz died that day? I think the answer is plainly obvious. Juan Davis wanted to be sure there would be no witnesses against him. So think about that for a moment. Angelica Figueroa lives under someone she considered her friend, her best friend. And that person who put Luis Diaz into his car seat communicated with the individual she knew she was supposed to have no contact with. She knew he was not supposed to be near that house. For what purpose? It's the state's belief this was to end his court case in a different way. So what did he do? What did Juan Davis do? Juan Davis, in the midst of having these quick conversations with Katherine Treadway, goes to his friend Tiffany and trades his car. We know which one. It's the blue Audi he didn't want to drive over there. He gets into the black Mercedes, gets two guys he knows will do what he wants, and drives them and lets them off and tells them what to do. Go put holes in that car. And as I said before, and I'll say it again, the precision of this is no coincidence. That this all happened as Angelica was leaving the driveway. Mr. Davis had decided someone was going to die that day and sent Devonte Parker and Jayden Sorensen to do it because he had the ankle monitor on. Let's talk about that for a moment. The community does not expect every person charged with a felony offense to sit in jail and wait for their case to go to trial. The community wants people to be out on bond so long as it is safe. Mr. Davis was on court supervised release and GPS exclusion zone. Two items which were meant to keep the community safe. He figured out his way around them. And that was to have two people do his dirty work for him. And that's where we get to Devonte Parker. Devonte Parker, Your Honor, is probably one of the most dangerous people you will ever have walk into your courtroom. And why do I say that? I sat here listening to Your Honor give the sentence in the last two defendants. And when the court, and I know you've said this many times to defendants, you talked about post-release control. Post-release control is meant to help offenders reintegrate and to keep the community safe. Mr. Parker was on post-release control when he did this. Clearly those things meant nothing to him. So think about that for a moment. Two different things that are set up to make the community safe and to have people in society both failed that day. Juan Davis found his way around court supervised release and GPS exclusion zone, and Mr. Parker didn't care at all that he was on post-release control after having served a prison term for violent offenses already. That's what makes Devonte Parker so dangerous. That combined with the fact that he was willing to take a gun, hand it to him, and shoot at whatever Juan Davis wanted him to. He never met Luis Diaz. He never met Angelica Figueroa. He never met Jose Mateo. He didn't know anyone over there. Yet, without hesitation, and you heard those 13 shots in this courtroom, no hesitation, to point a gun at this car and shoot to kill. He didn't know who he was killing, and it didn't matter to him. That makes him as dangerous as they come. I mention all of this. Because both have repeat violent offender specifications in this case. Both have shown to you, through their actions, that they need every day of it to be added on to this murder sentence. The murder of Luis Diaz was most definitely the worst form of this offense. To point your gun at a car and not care who's inside, and fire 13 times, 5 of which we know of, hit the back of the vehicle. So we know what the target was. That's the worst form of the offense. And to do it while out on bond on a violent offense, to do it while on post-release control for a violent offense, means the community is not safe with either of them on the street. Ever. Mr. Davis gave a statement to the police. In that statement, he talked a little bit about being a father himself and his affection for Luis Diaz, if you remember those statements, Judge. He knew who did this. And he sat there and pretended as though he had nothing to do with it. He lied and said this was about buying drugs from Jose Mateo. They got their sacks and I got mine, all of which was a lie. Because at the end of the day, Mr. Davis is a coward. To go and have 2 people do this and pretend you had nothing to do with it, pretend it was something totally different, that shows you the type of person who would do this in the first place. The state of Ohio is asking for these defendants, Judge, to be sentenced to the absolute maximum for the murder of Luis Diaz. The court has no discretion in the sentence. It is life with first chance of parole after 15 years. We're asking for 54 months to be added for his firearm specification for Mr. Davis, 3 years to be added for Mr. Parker's specification, and 10 years for the repeat violent offender specifications. We are not safe with them on the streets. With regard to the attempted murder counts, the state feels it was Angelica Figueroa who was the target here. Again, without her knowing it, without any of them knowing it. With me is the family, Judge, as you know. Angelica was not here this morning. She is here now.
She just had to step out.
All right. She'll be back in a moment. She is not able to speak at the moment. If I could just have
Lori, this is Selena, Celines, Rios, Rios, Callahan.
statement that said is that these are dangerous men. That they should be feared. These are not just dangerous men, they're scared men. Because when a man is scared, they do irrational things. They make irrational decisions. I'm sorry that from the time probably they were little, they've had something to be scared of. It shouldn't have been that way. It should have been protected. When Luis had started going on the bus to school, he had to go by himself. His mother had to put him in a harness because he was a runner, and they had to attach him into the bus. I said, Angelica, I feel scared for him because he's by himself. He doesn't know nobody. He's being put on a vehicle to go be transported somewhere, but he doesn't know. He doesn't have his family with him. He's by himself. So I made her get one of those things from iPod, AirPod thing. Got two. Because I figured if he got disconnected from his book bag, for the bus, we were gonna find him. Because our family protected him. He was protected. And because these two scared men, they never had that. They made some decisions that's taken him away. You guys have children. And you're supposed to be there to protect them. You're supposed to be there to make sure that what happened to you guys don't happen to them. Whether it be the fights in the playground, to show them how to hold up their dukes. Whatever the case may be, you're supposed to be there to protect them. And you failed. It doesn't mean you don't have time to redeem yourself. Because as big and scary as you are, there's somebody who's bigger and scarier. Believe that. That's all I have to say.
Thank you. This is Christian, Christian, last name Taulet. Mr. Taulet, what would you like me to know, sir?
Morning, Your Honor, again.
Morning.
Said it, I'll say it again, thank you God for another opportunity. Like, even for the defendants, that's how good God is. I just want to say I remember the day that I received the call and I left what I was doing and I rushed to the hospital. And when I got there, I told the doctor was going to tell me that my grandson was like an intensive care unit, but maybe a couple days from now, he'll be back. And even in a wheelchair, you're going to have him home. That wasn't the case. That wasn't the case. He came up to me and he told me, we did everything we could, but we couldn't save his life. He said, he had a big hole. We did everything we could and we couldn't save his life. since that day, I just couldn't think about, like, knowing who did this, why they did this, what was the reason behind it. And today I get to see both of you guys, and you guys are grown up men like me, and you guys made a big mistake, and I'm glad you guys got caught, and I'm glad you guys are gonna get sentenced and get the maximum penalty. I'm sorry, now that you made a mistake.
If you could
You guys-
face me, Mr. Thomas.
I'm sorry.
It's okay.
You guys made a mistake, you guys got caught. And the first time, you guys are gonna get sentenced. And I'm 47 years old, so I probably don't get to live enough to see you guys if you guys do come out of prison or something. And if anybody ever comes asking me if it's okay for you guys to come out on parole, no, man. None of that. Don't ask me for nothing. You guys get everything, the maximum you guys deserve. That's it, point blank. Glad that they got caught. I'm glad they're gonna do their time. And at least you guys are gonna be alive, even in prison. You're gonna have breakfast, lunch, and dinner. If you guys get sick, you guys are gonna get attended. You guys are gonna get taken care of. If I get sick, I gotta pay for my own medical problems and all that, So now I also gotta contribute to the taking care of these two criminals that took the life of my grandson. Not only the life of my grandson, I have his brother, Ezekiel, and till this day, he looks at the picture and he knows who that is, And like I said earlier, when I see this on the news, now I know how much it hurts. Now I know how hard it is for the family members going through it. And for me, this is like the end of it when it comes to solving the matter, the law. But let's see what God got for them, That's what I gotta say, Your Honor. Thank you, and
Thank you, sir.
Judge, just a few more comments. They didn't just kill Luis Diaz. They tried to kill everyone in that car. And for that, we're asking for consecutive sentences. I filed in this sentencing memo that the state is looking for a sentence of 49 to life for each of these defendants. And I'll leave off with this. I never got to meet Luis Diaz. We heard during her testimony that the school he attended dedicated a buddy bench to him. And I think that's fitting. Because every picture I've seen, save the autopsy photos, every picture I've seen, he's a smiley little kid who looks like he would be your friend. They took that from all of us. And for that, they need to pay. Thank you.
Thank you. Mr. McNeil.
Thank you, Your Honor.
You're welcome.
This is it's a very tough sentencing hearing for me to conduct due to the gravity of the loss in this case, which is not lost on anybody present here, I believe, including Mr. Juan Davis. He himself has came out as a father himself of many children, 15, I believe. 17, Your Honor, ranging in ages from toddlers to some adults, Your Honor. Throughout the course of this case, he has always expressed deep remorse over the fact that decisions that he made culminated in the violent death of a 3-year-old child. I have advised Mr. Davis against making certain statements here today because of his rights to appeal, Your Honor. But I know that this man has dealt with depression, severe depression and suicidal ideation since he has been in pretrial custody. I know that he has a history of various mental health disorders, which was articulated in the February 23, 2024 competency evaluation. That report indicates that Mr. Davis not only has suffered from depression and psychological, depression and suicidal ideation, but he also has suffered with a bipolar, with psychotic disorder. And I think it's very important for the court to consider that when it considers the events that culminated in Luis Diaz's death and in this entire assault. The state has indicated and has presented a case where it is almost as if they believe that Juan Davis acted in cold-blooded deliberation when this incident unfolded. And that's not what I believe the facts and evidence show here. What I think this shows are a snapshot of various problems that plague not just Mr. Davis, that plague our entire society here. We want to look at the mental health and substance abuse issues. Mr. Davis, with all of these depressive disorders and anxiety disorders, and his bipolar disorder, was smoking marijuana again. He's hanging out with other individuals who are armed, many of which appear as though if they're not active gang members, they're at least living a lifestyle not inconsistent with gang culture. The prevalence of guns, the nature of the toxic relationships will set this off, Your Honor. We all saw the voluminous phone calls and messages that were sent to Mr. Davis from Ms. Treadway, which set all of this off. Calling from Star 69. Her behavior can only be described as telecommunications harassment, and it doesn't excuse the decisions that were made here, Your Honor. But I only ask that this court considers the human impact on an individual who already suffers from all of these mental illnesses, who's already had a dysfunctional childhood. He was raised by his grandfather because his mother couldn't do anything with him. His father was nowhere around. I believe this incident, while tragic, is just a snapshot of all of these issues that we have to deal with as a society. It's natural for our society and our community to want to call for the maximum sentences here, for these two individuals to be held ultimately responsible for the acts that led to Mr. Diaz's death. I understand the outrage. I'm not even going to say that the outrage is misplaced, but I will say that we should all perhaps look at what we can do and how we can work better, how our system can work better so that we can actually deal with these issues of mental health, so that we can deal with these toxic relationships, so that we can deal with just generational traumas and maladies that create not just the Juan Davises and Devonte Parkers, but all of these individuals in our society who are suffering right now, Judge. I believe a sentence of 22 and a half to life would be more than significant to achieve the purposes of felony sentencing here, to account for the specifications, the 54-month specification, as well as the RVO specification. I would ask for the court to find Mr. Davis indigent for the purposes of fines and costs. As a smaller matter, I would ask Mr. Davis had multiple vehicles that were impounded by the police department. I would ask that the court release those vehicles or allow him to get them released through power of attorney. And I don't want to face the family, but I would like the court to note that again, we all agree, we all share deep empathy with what the family is going through. And I agree with one of the statements that was just made, that my client was a scared man. He was a very scared and anxious man. And I hope that he can redeem himself because he has so many children. His legacy is so long. And I'll simply ask that the court impose a sentence of 22 and a half to life. Thank you.
Thank you. Mr. Davis, I understand your attorney has expressed that he's advised you not to make a statement. I have to still ask if you wish to say anything for purposes of today's hearing. Okay, go ahead.
Sorry to the family. Wish it wouldn't happen.
I apologize.
Bring back. Sorry.
Thank you. Mr. Spelenstein.
Thank you, Judge.
You're welcome.
Judge, kind of starting where Mr. Filiatro started, as it relates to the Beatty case, I just suggest to the court that is advisory. I understand that, but I think the court, as you know, you have plenty of other options here besides adding additional specs where the court has signaled to us that 6 is enough. Having said that, Your Honor, I know that the same thing is true for my client. He would like to exercise his appellate rights. As such, he will say very little here today. And finally, he is an indigent judge, and the court knows that. If you consider that when you apply fines and costs in this matter, to be appreciated. Thanks very much.
Thank you. Mr. Parker, same thing. Your attorneys let me know that he's advised you not to speak. I have to give you the opportunity to say anything that you wish for purposes of the sentencing. Is there anything that you wish to say?
Yes, I would like to speak.
Okay, go ahead, sir.
First off, I'd like to say to the family, if I was a guilty man, I will own up my guilt, especially in the death of a 3-year-old child. I got children of my own. I got 3 daughters and a son, a 1-year-old son to be exact. So I want to say my condolences to y'all. And if people feel that this is justice, if I'm guilty, based on what we were saying, everybody sat through the trial. So you see what I was up against. So I would just like to say my condolences to y'all. And I pray I keep y'all in my prayers, and I ask that God keep a hand over y'all family. And that he shield y'all with the power of the Holy Spirit. I would like to say that. Amen. That's all I have to say.
Thank you, Mr. Parker. You can have a seat. Okay. I have considered all of the information that's been presented here today. I've reviewed the purposes and principles of sentencing pursuant to Revised Code 29.11, the serious and recidivism factors relevant to these individuals, and this case pursuant to Revised Code 29.12, and the need for deterrence, incapacitation, rehabilitation, and restitution. But most importantly, I sat through this trial. It was 10 days of testimony, 10 days of evidence. So the facts, I am more than fluent with how we got here today. And this is a separate sentencing hearing. We had a different sentencing hearing this morning for the other 2 co-defendants. But I said something that I think it's important to say it again. The actions here today have stolen the life of a baby. And it will never leave my mind that that little boy, I will probably picture him in my head for the rest of my life, was 42 inches tall. And I do not know why this sticks with me so much, but it's haunting because he was so tall. And we never are going to find out how tall this little boy was going to be because his life was stolen from him. He's never going to grow up. We are never going to see how tall he was going to be. He's never going to get a driver's license. He's never going to fall in love and have the opportunity to have his own kids. And that is heartbreaking. And I think it's important that I say it twice. because this is a separate hearing. Now, I don't disagree, Mr. McNeil, with what you talked about the problems plaguing our society, but I need to point out that I'm well aware of Mr. Davis's diagnosis. He was placed on, he's the reason that this case is on my docket, because I'm a mental health court judge. That's why I have this case. And immediately upon getting his first case, I put supportive services in place. He has had the supportive services of the mental health docket in the past. The court has attempted to address all of the issues that we were talking about, and they just did not work. He was on court supervised release with the monitor when this happened. So while I agree with you, I'm done giving the chances to Mr. Davis. Okay, for both individuals, I agree with the mergers that were placed on the record by the state of Ohio, and further, I am going to sentence only on 2 of the firearm specifications. I am required to sentence on at least 2 of those to be served consecutively. I will not sentence any further on those firearm specifications. For Mr. Davis, the firearm specifications, you have 54 months, 3 years, 18 months, and 1 year. They all merge to the 54-month firearm specification. I'm sentencing you to that 54-month firearm specification in count 3 and count 10. And those run consecutively. They are required by law to be run consecutively, so that's 9 years of mandatory firearm specification time. This firearm specification time will be served prior to and consecutive to the underlying sentence for count 3, which is life with the possibility of parole after 15 years. Further, I've been a judge. I'm in my 11th year. I have never once imposed repeat violent offender specification time. If ever a case deserved that time, it is this case. I am finding that the offense here, count 3, is the offense of murder. I have imposed the longest prison term for the offense. I'm finding that the prison terms under subsection B, 2A, subsection 3 are inadequate to punish and protect the public from future crime under Revised Code 29.12, and that the prison terms under that same subsection above are demeaning to the seriousness of the offense because one or more factors under Revised Code 29.12 indicate that Mr. Davis's conduct is more serious than conduct normally constituting the offense. And they outweigh all the factors indicating Mr. Davis's conduct is less serious than conduct normally constituting the offense. I'm adding 10 years to the sentence on count 3. Count 10 is the qualifying offense. And I have already imposed the 54-month firearm specification time for that charge. That will be served prior to and consecutive to the indefinite sentence of 10 to 15 years in prison. The sentence for count 7 and count 12 are each 5 years in prison. And the sentence for count 17 is 3 years in prison. So adding all of further, I am finding that consecutive sentences are necessary and warranted in this case. I'm ordering Mr. Davis to serve the sentences on counts 3, 7, and 10 consecutively. After reviewing the record and the evidence, I find that consecutive sentences are necessary to punish Mr. Davis, to protect the public from future crime, and are not disproportionate to the conduct or danger posed by Mr. Davis. And I can find all 3 subsections that apply in this case. I only need to find one. Mr. Davis's criminal history demonstrates that consecutive sentences are necessary to protect the public. I can also find that Mr. Davis's offenses are part of a course of conduct, and that the harm caused was so great, meaning the loss of life of that little boy, that a single prison term would not adequately reflect on the seriousness of the conduct. And lastly, that Mr. Davis was on court supervised release and under the supervision of the probation department when this offense happened. Counts 12 and 17 will run concurrent. Adding all of that up, the sentence for Mr. Davis is life with the possibility of parole after 49 years. Please be quiet. I apologize. I'm doing that respectfully. Mr. Parker, you have firearm specifications 3 years and 1. They merge, and I am only going to sentence you on the 3-year firearm specifications for counts 3 and 10. I am required to sentence you on those terms consecutively, so you will serve 6 years for the firearm specification on counts 3 and 10. That firearm specification time will be served consecutive to the sentence for count 3, which is life with the possibility of parole after 15 years. I'm also going to order the repeat violent offender specification, finding that this is an offense of murder. I've imposed the longest prison term for this offense, and I find that the prison terms under subsection B2A3 or III are inadequate to punish the offender and to protect the public from future crime under Revised Code 2929.12, and that the prison terms under that same subsection are demeaning to the seriousness of the offense because one or more factors under Revised Code 2929.12 indicate that Mr. Parker's conduct is more serious than conduct normally constituting the offense and outweigh all factors indicating the offender's conduct is less serious than conduct normally constituting the offense. I'm ordering 10 years of repeat violent offender specification time. Count 10, I've already imposed the 3-year firearm specification. This is the qualifying offense, so that firearm specification time will run prior to and consecutive to the indefinite sentence of 10 to 15 years in prison. The sentence for count 7 and 12 are each 5 years in prison, and the sentence for count 18 is 3 years. I'm further finding that consecutive sentences are warranted, and I'm ordering Mr. Parker to serve the sentences in counts 3, 7, 10, and 18 consecutively. After reviewing the record and the evidence, I find that consecutive sentences are necessary to punish, to protect the public from future crime, and are not disproportionate to the conduct or danger posed by Mr. Parker. I'm also finding that Mr. Parker's criminal history demonstrates that consecutive sentences are necessary to protect the public, and that Mr. Parker committed these offenses while on post-release control. Count 12 will run concurrent for a total prison sentence of life with the possibility of parole after 49 years. As it relates to the qualifying offenses, when it is presumed that you will be first of all, let me go back. When you have your firearm specification time, that's mandatory sentences. That means that you're not eligible for good time credit. But once you finish your firearm specification time, it is possible for you to earn good time credit, and that ranges anywhere from 5 to 15%, and that is for good behavior. I have the right to deny your good time credit, but before that could happen, I would assign an attorney to represent you, and we would conduct a hearing. As it relates to these qualifying offenses, you will be released when you finish your minimum term, unless the Ohio Department of Rehabilitations and Corrections determines that you must remain in prison for bad conduct. That decision is made by the Ohio Department of Rehabilitations and Corrections. If you are not released when your minimum term ends, You will serve an additional specified period of time and be given a new release date. You will be released on that date unless you are again denied release for bad conduct. This process repeats until you are either released or until you finish your maximum term. When you are finished serving your prison sentence, the State of Ohio Adult Parole Authority will have a mandatory period of supervision. It's post-release control. For both of you, it's a minimum of 2 years, up to a maximum of 5 years. If you fail to comply with the terms of any post-release control supervision, the Adult Parole Authority could modify or extend your supervision and make it more restrictive. They could incarcerate you for up to half of the sentence I've imposed here today. It could charge you with a new offense called escape, another felony where you would face additional prison time. And if you commit a new crime while on post-release control, you could face the maximum penalties under the law for that new crime committed. Mr. Davis, you have 508 days of jail credit. Mr. Parker, you have 505 days of jail credit. That will go towards the sentence I've just imposed once you finish the firearm specification time. For both of you, I am finding that you are indigent, and I'll waive the fines and court costs associated with your cases. To each of you, you have an automatic right to appeal your judgment of conviction. You have a right to have a notice of appeal timely filed on your behalf. I'm finding both of you indigent, and I will appoint counsel to represent you on appeal and provide a transcript of all the proceedings in this matter at the state's expense. Mr. Davis, I'm appointing Joe Pagano to represent you. Mr. Parker, I'm appointing Jay Schlackett to represent you on appeal. Mr. Filiatro, do you have a response to Mr. Davis's request for vehicle releases? Or would you like to address that at another time?
If I could address that separately, I'd appreciate it. Thank you.
That is not a problem. We'll hold off on that matter. We'll get a separate issue. We'll get a separate ruling at a later time. Anything further on behalf of your client, Mr. McNeil?
Nothing further, Your Honor.
Thank you. Mr. Spellacy?
No, thank you, Judge.
Thank you. And on behalf of the state of Ohio?
No, Judge, thank you.
Thank you. We are adjourned.
Yeah, I'll be with you. I'll come back there.
Chris?